back to Capitol tonight. Abortion bans, like what Texas implemented, are testing a federal emergency medicine rule. It's called the Emergency Medical Treatment and Labor Act, or EMTALA. Under it, hospitals are required to treat and stabilize any patient experiencing a medical emergency. The U.S. Supreme Court is hearing arguments next week about an Idaho case. The Biden administration sued Idaho, saying that state's abortion ban violates EMTALA because its exceptions are too narrow to allow doctors to perform abortions if needed to stabilize the patient. That ruling is expected to affect a Texas case where the state sued the Biden administration, saying it's using EMTALA to get around state abortion bans. Joining us now is Seema Mohapatra. She's a law professor at Southern Methodist University who specializes in health law. Professor, welcome back to the program. Nice to see you.
Thanks for having me.
This is a complicated issue, but Texas actually laid the groundwork for this federal rule. I mean, why did EMTALA get implemented in the first place?
Yeah, EMTALA got implemented because there were a lot of hospitals, private hospitals, that were turning away patients if they didn't have the ability to pay, including in Texas. And so public hospitals were getting patients that were literally pregnant women that were in labor and that were turned away from a private hospital, including in Texas, and they were ending up having to, sometimes delivering in the parking lot, sometimes delivering, in the hallway while waiting, including in Texas, like at Parkland, the public hospital in Dallas. And so Texas was actually one of the first states to have an anti-dumping law that would prevent hospitals from doing that. And that's what the federal EMTALA Act was kind of based on the Texas law.
Well, so now we have, this federal rule based on what the state did, but federal law usually trumps state law in my legal experience. That's the big question here, right? What could the outcome of the Supreme Court ruling on Idaho's case mean for Texas potentially?
Well, so if the Supreme Court decides that the EMTALA's definition of what an emergency medical condition is and about stabilizing, if it conflicts with state law, if EMTALA trumps that, then that would impact all 50 states, including Texas. If, on the other hand, they say, no, Idaho's law, that the narrow abortion exception would trump federal law, then that would also be the case in Texas, even though that wouldn't, Texas is not in that case. Mm-hmm. However, it would impact the interpretation of how state and federal law kind of coincide.
Well, so that's been a big question among doctors and the lawsuits that are currently here in the state of Texas. What about clearing up the medical exception language as some of these plaintiffs are trying to do, this stabilizing anyone experiencing a medical emergency language in the federal rule? That seems confusing for doctors who are trying to balance the state law.
This is a confusion that physicians have, and this is why we have so many patients that are saying that they're getting delayed or denied care because physicians are not sure how to interpret it. And so, yes, we could get information about clarifying what that means, but I think it's more likely that we're going to get the Supreme Court's kind of decision on whether the EMTALA's language is going to take over, as would typically be the case, or if they say there's no situation in which a abortion, for example, could be needed for to stabilize or treat a patient, which we know medically is not true. And so, we're going to be watching to see what the questions are like next week to kind of get an idea of what the Supreme Court is thinking.
Seema Mohapatra, thank you so much for your time.
Thanks so much for having me.